All rise.
Please be seated. We'll hear argument in 22-1085, Keys against Weller.
May it please the court, Mr. Ritchie will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court, this case, the issues before the court today have been addressed by this court before, and apparently by many, many courts in the state of Texas, having to do with when, if at all, owners of limited liability companies, officers of those companies, or agents of those companies can have personal liability for things and acts that they do or don't do when representing the entity. I saw the clerks putting on the bench beforehand 2 binders. There's a binder from us with 2 documents in it, a binder from the respondent with 1 document. I would ask the court to please look at the binder from my opponent. It's actually got the Article 21223 from the Texas Business Organizations Code, and that's the subject matter of today's argument, and I'll be referring to it. Thank you. This case happened when there was negotiation going on between a company called Monocoque Diversified Interest, LLC. That's the last time I'll say that, because if I keep repeating it, it'll be all day, and I'll use my whole 15 minutes. I'm going to refer to them as MDI, if you don't mind, if I may. MDI, through its 2 owners, Ms. Keyes and Mr. Nadeau, the sole owners of MDI, was negotiating with Mr. Weller and one of his companies, Integratech, with respect to some agreements to come into their aviation parts business. They buy and sell the next level aircraft, might buy them from Delta or United. They might refurbish some of them. They might take them apart and sell parts, and they might sell the whole aircraft to next generation users. Mr. Weller was in that same industry. They needed some help. They were negotiating for him to come in as an employee and for Integratech to be a consulting company to help train the employees at MDI, which was a fast-growing business. That deal went on from early in 1 year, like January to May, and then it came apart. But Mr. Weller did come to work as an employee. There never was what we would call a written agreement, a document that's prepared and signed by the parties. Mr. Weller relies upon a series of emails and says that's the contract. MDI, Ms. Keyes, and Mr. Nadeau said that was negotiations. We never contracted. Mr. Weller brought a lawsuit against MDI on a bunch of claims with respect to compensation under the contract that he alleges existed and that they deny exists. So there is a contract, an oral employment agreement that Mr. Weller came to work, and it's an at-will agreement. It's the only agreement. And there are a series of emails.
So you'd say that's a contractual obligation of the corporation under 223A2?
If it exists at all. It would be an obligation of the entity. It's not a corporation, Your Honor. It's a limited liability company, but same thing. It's an obligation of the entity, if it exists at all. And that's kind of where we get to here, which is the most interesting point to me. Mr. Weller asserted that they defrauded him or that they misrepresented certain facts. And if you look at our binder, which you have in front of you, and you look at tab 1, it's the plaintiff's second amended petition, which in fact was the live pleadings. Judge Mousy, in her order, granting our summary judgment on behalf of Ms. Keyes and Mr. Nadeau, said in her order, which you can find at the volume 1, 275 of the court's record, literally said that she had considered the pleadings, the relevant evidence, the case law, and granted the summary judgment in favor of Ms. Keyes and Mr. Nadeau and dismissed them from the case. We severed the case because neither party wanted to go try this case twice. And then that severed case is what's before you today. The respondents appealed the summary judgment to the 13th Court of Appeals. 13th Court of Appeals really didn't consider the allegations that were made by the petitioner. They talk about them sort of, but they don't say that that's what they base their opinion on. They say they base their opinion on the clear law in the state of Texas that individuals can be personally liable for fraud or misrepresentation or torts committed even when they're acting on behalf of the entity. And this court has said in 2022 in the TransCore case that, yeah, you can sue the corporation or you can sue the individuals. Take your choice. Well, they sued them both. If you look at those allegations in our tab 1, which is the second amended complaint.
So why doesn't TransCore give us the answer in this case?
I'm sorry?
Why doesn't TransCore give us the answer to this case?
Well, it kind of would, because in TransCore the court found that there was no personal liability because there had been a settlement.
I'm talking about the legal principle that you mentioned,
Okay.
that you can sue either the individual or the corporation or
Sure.
LLC or both.
We don't disagree with that. In TransCore, there was a allegation of bribes, close to $100 million in bribes that were discussed as being paid to corporate representatives in order to sign a contract with the other party. Then there was a settlement agreement in which...
I thought your position was that 21.223 was the only method and they couldn't be held individual, and 21.224 preempts, so you can't be held individually liable.
I could argue that, Judge.
Oh, I thought that was your argument.
Well, it is part of our argument, but even if this court said, as they did in TransCore, that, oh no, you can have individual liability. You took a bribe. You know, that's outside of the constructs of the contract itself. You took a bribe. Or there was another case in which, Leindecker actually, in which the allegation was that there had been a libel committed against a homeowner, a building owner, I'm sorry, when it was reported to the Houston Builders Association that they had done something that they were claiming they didn't do, and that libelous activity is outside of the contract. 21.223 literally says that to get to an owner of an entity, you've got to show that the matter that you are, the contractual obligation and any matter relating to or arising from that obligation is on the, you committed actual or constructive fraud or a sham to perpetrate a fraud or similar theory. The section B of that section says, and then as to owners, you can only reach them if you can show a direct personal benefit to the holder, beneficial owner, or subscriber or affiliate. There's not even an allegation that Ms. Keyes or Mr. Nadeau had a direct personal benefit other than a statement that if they did these deeds that Mr. Weller alleges, if they did, that their benefit is because they're shareholders of the corporation and the corporation benefited. If that was the law, it would negate 21.223.
Well, B seems to be saying that they can't be held liable for any fraud. They can't be held liable for any obligation of the corporation. But if they're being sued for their own fraud, that's not a contractual obligation, and it's not the corporation's obligation either, right? They're being sued for a freestanding cause of action based on fraud that doesn't arise from the obligation necessarily, and it's not them being held liable for the corporation's fraud. So I guess I'm struggling to see how 21.223 bears on fraud that an individual commits while they're while they're acting as an agent of a corporation.
When I read all the cases, including the Western District's opinion in Bates that went through the history of this question of personal liability, they all are consistent in one thing. There has to be fraud or a tort, not just alleged. There has to be sufficient pleadings to actually establish fraud And Judge Mousy says she considered the pleadings.
But it doesn't have to be fraud by the individual holder. It just says on the basis of actual or constructive fraud, a sham to perpetrate a fraud or other similar theory. It doesn't say fraud by whom.
You're talking about B. now.
Yep, A2.
A2. It starts off in A, a holder of shares, an owner or beneficial interest in shares, or a subscriber for shares. So that's who A is talking about.
Right? No question that
So it's not
Ms.
a thing.
Keyes and Mr. Nadeau are holders.
No question.
Okay. So why is if they're being sued for their own fraud, why are they being why is there a threat of them being held liable for a contractual obligation of the corporation on a matter arising from that obligation on the basis of fraud?
Well, my answer to that would be found in the pleadings that I've asked the court to please look at in our book, which is Exhibit 1. No, I'm sorry, Exhibit 2. I'm wrong. Exhibit 1. And go to paragraph 24. Here's what they're claiming. Every single element, every single specific claim that they make has to do with negotiating terms. There's not a fraud or a tort alleged in this pleading. As owners, they said that, I'm sorry, look at 24. As owners, I'm not going to read all of them, but if you look at them, there's not a tort even alleged, with the possible exception of a tort. It could be one in paragraph, the last part, which says the MDI had the financial capacity to fully fund the above compensation elements, and that the timing was right in MDI's corporate history to bring on plaintiffs under the terms described therein. They'd offered no proof that MDI wasn't solvent. In fact, it was, and had all the capacity to pay this. So they didn't bring Judge Mousy any proof that that was fraud. And as this court has recognized time and again, a summary judgment hearing is a trial. They had the opportunity to bring forth evidence. Judge Mousy says, I looked at the pleadings, I looked at the evidence, I heard the arguments of counsel, and the summary judgment should be granted, and she granted it.
So you're saying it doesn't really matter whether 21 to 23 or 24 apply or not, because there's just no evidence of fraud,
Absolutely.
period.
And the allegations that they made, it started off with this is a second amended pleading. The first amended pleading didn't have specifics. We filed special exceptions. Then there's new pleadings filed with these elements. What is it that they did that you're claiming is fraudulent? Well, they negotiated contract terms, which MDI says never even got into a contract. But let's suppose they did get into the contract, and that at a trial, the court finds, or a jury finds, all of these elements are in the contract. Well, then there isn't any fraud. These statements were true. And so
The statute talks about a holder of shares or an owner of a beneficial interest. What if an owner or a holder of shares serves in a dual role as a holder or owner of shares, and then also in a decision-making capacity for the corporation?
And they
like
did.
as an officer or director or...
And they did. Ms. Keyes was the
Right.
chief.
And so is liability here being sought to be imposed in their position as an owner or holder, or in their position as an officer of the company?
Well, perhaps
who's authorized to act on behalf of the
I
company?
apologize.
No, you're good.
Perhaps I've confused the argument. What we're basically saying is they can't be liable as owners because they were negotiating a contract.
They can't what?
They can't, as owners, as shareholders, as unit holders, be liable because that would negate this statute, this code section. So now we go to, can they be liable, as you've asked, Judge Bland, Justice Bland,
Officers.
as an officer? And they were officers. And yes, they could, but you have to look at liable for what? There has to be a clear tort that's pled. There is a case that's not out of this court called Argent Holdings versus El Paso. That court clearly stated that what is the rule of law when they said a complaint requires more than labels and conclusions and a formulaic recitation of the elements, and must state more than unadorned, the defendant unlawfully harmed me. accusation.
So your argument with respect to the officer liability, individual liability as an officer, is that they simply haven't pleaded an individual tort liability against these officers, that everything they did was in the course and scope of their role as officers at the company, and they didn't achieve any improper benefit, and so for that reason they just can't be held liable as officers either, but not the statute.
Well, the statute goes on to, first of all, we don't think they can be held liable at all as owners. But the statute says if they were going to be held liable for fraud as owners, you would have to show direct personal benefit to the holder.
Right.
And they didn't show
so
that.
This statute seems to absolutely protect passive owners who are not acting on behalf of the corporation. But how does this statute play in for an owner that's also an officer?
I think as a shareholder, they'd have no liability. As an officer, they could have liability under your transfer holding if you show there's a tort. And then you go to the pleadings, and Judge Mousey's ruling, there was no tort. So how could this have gone differently?
So they didn't prove it.
They
They could be as an officer,
They
they
didn't
just didn't prove it.
and they didn't move for a competing summary judgment on the fact that the series of emails, in fact, constituted a contract. They didn't prove contract. They didn't plead a tort. They didn't prove a tort. There's no liability.
Any other questions? Thank you, Mr. Ritchie.
Thank you, Judge.
We'll hear from the respondents.
May it please the court, Ms. Anton Georgiou will present argument for the respondent.
Good morning, and may it please the court. I want to start by noting what this appeal is not about. There was only one ground, of relevance to this appeal, there was only one ground asserted in the motion for summary judgment, and that was that this statute barred the intentional and direct liability fraud claims alleged against the petitioners. There was no challenge to the sufficiency of the fraud pleadings. That was just not in there. And
No evidence motion or anything
there
like
was
that.
no
on
no
fraud.
evidence motion, and if there was, it would be their burden to demonstrate that we have conclusively failed to establish any evidence of fraud. That is a distinct fact issue that needs to go to the jury. This is a very narrow motion for summary judgment, and we should be just focusing on the ground alleged, and that is that this statute bars direct liability fraud claims against agents of a corporation in virtue of their status as holders. And I think that if you look at the statute, it's fairly clear that it does not. I have 2 points that I really wanted to make with respect.
It sounds like they basically agree with you about that now, that the statute doesn't bar you seeking to hold anybody seeking to hold a holder liable if it would in their capacity as a holder perhaps, but if they're also an officer or an agent and they're acting in that capacity, then they can be held liable under transcor for their own fraud.
I think that is correct, and I think
It sounds like they do too now.
yeah, that for direct liability tort, which respectfully we have adequately alleged in the pleadings, which must be interpreted broadly.
So are you saying now that because they agree with you, that's the end of it?
Well, I mean, I presume that the justices are still going to consider and evaluate the argument unless the petitioners are waiving their argument that this.
They seemed to concede it a moment ago.
Well,
We'd still happy to hear your argument on it.
okay. Well, I prepared my argument regarding the statutory interpretation if you'd like to hear it.
Do you want to respond to what he is arguing right now?
Well, with respect to the adequacy of the pleading allegations.
And the evidence.
And the evidence, yeah. I mean, first and foremost, I think that that is beyond the scope of the motion for summary judgment. And summary judgments can only be granted on the grounds that were asserted. And this was the only ground that was asserted, that as a matter of law, this statute barred liability for these claims.
Well, is their argument that you haven't pleaded any other kind of fraud on behalf of these individuals?
I think we've.
So that's, that basically the fraud that you have specifically alleged is the fraud barred by this statute, and you haven't pleaded other fraud?
I think that the petition, any reasonable interpretation of the petition would find otherwise. We've clearly identified them individually in their individual capacity as being liable for the fraud. They're named under the cause of action statutes. Their role in the company as owners and presidents and representatives of the company appears throughout the petition. But again, I think that the adequacy of the pleadings is not, the adequacy of the fraud allegation is not before the court.
If you want to spend some of your time addressing the meaning of the statute, I think that might be helpful. I'm not convinced that this does not protect people from individual liability, irrespective of what hat they're wearing.
Sure. And I would refer the court to Respondents Exhibit 1. This is 221, 223, and 224 of the Texas Business Organizations Code. And there are two main points that I want to make with respect to an analysis of the text that I think really demonstrate that this statute is only intended to apply to vicarious veil-piercing claims. The first is that this statute is focused on, quote, obligations of the corporation. And I've highlighted spaces in blue. I've highlighted in blue where you see that that reference throughout. And A2 specifically says applies to any contractual obligation of the corporation or any matter related to or arising from the obligation being the contractual obligation of the corporation. 21224 also refers back to that obligation. And even subsection B of 223, that is a reference to subsection A2 liability. So everything is centered and focused around liability for an obligation of the corporation.
And a contractual obligation at
And a
that,
contractual-
not a fraud, not a tort obligation.
That is true with respect to A2, yes. Yeah.
But doesn't A2, the latter part of A2 suggest that fraud allegations against an individual can relate to or arise from the corporation's obligation, right? Or else the second part of A2 that mentions constructive fraud wouldn't
Right.
exist.
Okay, well, I have 2 points that I would like to make with this. The first, I'm going to go primarily to your question, and this has to do with the list of vicarious liability, veil-piercing liability theories that come in the second half of A2. And I think that it's important to note that it's a non-exhaustive list, but it's all about veil-piercing theories, and that's the way that other courts have interpreted it consistently for the past 20 years. And I think they do so for good reason.
Those are the ones we set out in Castleberry.
That is correct. And those claims are drawn from Castleberry, which Castleberry was entirely a veil-piercing case.
But Castleberry has largely been replaced by the Business Organization Code in lots of different places, not just this one, for the reasons that it was a difficult case to apply in terms of corporate governance.
Yes, I agree, Your Honor. Castleberry prompted the enactment of the statute, and I think the legislature was clear that they intended to clarify and limit when these veil-piercing theories could apply. Nonetheless, in Castleberry, the discussion is around the veil-piercing jurisprudence, which at that time is very convoluted and muddled. You have sham to perpetrate a fraud, actual fraud, constructive fraud, all confounded with alter ego theories, and there's no clear delineated standard. Castleberry mentions actual or constructive fraud as one of the grounds used for veil piercing, notes that it is synonymous with sham to perpetrate a fraud. And I believe that the reference to actual fraud or constructive fraud in this list of veil piercing theories is a reference to the veil piercing theory. And I would also note.
So it would be actual or constructive fraud by the corporation?
No,
whose fraud is it? The statute doesn't say, but what's your position? It just says on the basis of actual or constructive fraud. It doesn't say whose fraud, but what's your position on whose fraud that is?
I think it would be anyone's fraud. It would have to be something on behalf of the corporation.
But if it's the holder's fraud, wouldn't that then presume that the holder was acting in some capacity on behalf of the corporation?
Yes, and the holder,
And so that sort of undercuts the idea that it's only in the role as holder that this protection against liability applies.
Why would it necessarily have to be fraud by the holder on behalf of the corporation? It could also be somebody else's, some other officer's fraud who was not the holder on behalf of the corporation, but then the result of the fraud would be that they could pierce through to the holder.
yes, the result would be that the veil could be pierced, and that's what this is about, these veil piercing theories. So it could be somebody else's fraud,
Right, but
yes.
what if it does mean it's the holder's fraud?
In the
Because the whole
instance,
statute is about the holder of shares.
I believe that the whole statute is about limiting liability to the holders in virtue of their capacity as such, and that those obligations are strictly corporate obligations,
But
the
if you look at
corporation's.
subsection B,
Yes.
right, it limits the limitation of liability when it's the holder that caused the fraud.
Subsection.
So that makes it sound like the holder's acting is not just passive, but is acting in some decision-making capacity. I'm just trying to,
Yeah, I apologize for
It's complicated.
interrupting. I believe that subsection B references and only comes into play if subsection A2 is satisfied, right? So it's saying that in this instance, even if subsection A2 is satisfied, you can still pierce the corporate veil if you satisfy this. But I still think that it doesn't have any application to non-veil piercing theories and direct liability theories.
So maybe one way to help me understand your argument, would you agree with this, that when it says actual or constructive fraud in A2, you're saying that doesn't really mean actual or constructive fraud in the way we would normally interpret those words. It's sort of a term of art that refers exclusively to fraud in the use of the corporate form, such that there be a veil piercing question.
Yeah, I think that that is correct. And I think that courts still acknowledge that in the context of piercing the corporate veil, actual fraud is not equivalent to the tort of fraud. And they refer back to the standard set forth in Castleberry when submitting jury questions on when it's appropriate to pierce the corporate veil.
It's sort of an interesting statutory interpretation question, I think, because you can look at the Castleberry case and your argument, makes some sense that must have been what they were responding to, and it uses some of this language. But then you just read the language, and claims of actual or constructive fraud against an individual, relating to the obligation. I mean, it's in a textual vacuum, it's very easy for me to see the other side of this argument. And so the question is sort of, to what extent should the court look behind the text and ask whether words like actual or constructive fraud are actually being used in terms of art without any obvious textual indication that they're being used in terms of art?
I think that there's a couple things that you can look at with respect to that. Number one is the jurisprudence continues to refer to actual fraud in the veil piercing context as distinct from fraud as a direct liability tort. The second one is that I would again point to the fact that this statute is really about obligations of the corporation and when you can hold an individual liable for those obligations. And that necessarily means a veil piercing theory, right? It's not a direct liability theory.
But relating to or arising from is creates a fairly expansive universe around the contractual obligation itself, within which all kinds of claims might fit.
How narrowly or broadly you interpret relating to or arising from, I believe there is some discretion in how you can interpret that. But I think that the legislative history, as well as the language used, the fact that it says any matter relating to or arising from the obligation, the contractual obligation of the corporation, I think that those facts, coupled with the laundry list of veil piercing theories, gets you to a point where you acknowledge that really has no application to direct liability torts.
But ordinarily, we don't think of negotiating employment contracts on behalf of a company where there's no improper benefit to the company as the employee being potentially directly liable, individually liable for undertaking those negotiations on behalf of the company. You seem to be saying that they would be.
I do believe that they would be. If I go and I fraudulently induce you to enter into a contract, I am liable for that fraudulent inducement. And I think the economic loss doctrine jurisprudence on this point is quite clear. The contractual obligation of the contracting entity is an independent legal duty from the obligation not to fraudulently induce someone to enter into that contract. And be it an employee, a president, or whatnot, if I induce you by fraudulent and false statements that you rely upon to your detriment, you're going to be liable for fraud. Yeah.
The corporate veil is not as valuable as many might think it is, given the ease with which these fraudulent inducement claims are thrown around in a lot of these business cases. It seems like the individuals responsible for negotiating the deal are almost always going to be defendants if the law is as clear as you're saying it is on that point.
I'm sorry, Your Honor. I didn't understand the question.
I mean, what I hear you to be saying is if there's a fraudulent inducement claim surrounding a business negotiation, then the individual officers who negotiated it allegedly fraudulently are valid defendants. And my point is there is almost always a fraudulent inducement claim floating around in these big business negotiation cases, which means that the individuals are defendants and the corporate shield or veil is perhaps not as valuable as many may assume.
I think that the corporate veil remains viable and is very difficult to pierce in Texas jurisprudence generally. I think it's well regarded and the corporations are given due respect. I think that the question about how fraud claims can get pled and prosecuted is separate and distinct from the questions about whether or not a direct liability fraud claim should remain viable and open.
But if you're saying that this statute that limits liability in these kinds of cases depends on the hat that the person is wearing, whether they're just an owner or an owner plus, how is that consistent with subsection B that seems to remove limitation of liability when you are the perpetrator of the fraud and you received a personal benefit?
I believe that subsection B is limited to the application of subsection A2. It only addresses liability that is encompassed within there.
Right, but why would you even need A2 why would you even need subsection B if A2 didn't cover a holder's decisions and actions?
I think that what subsection B is doing is saying, if I want to pierce the veil and hold you liable, right, in virtue of veil piercing, you need to have obtained some benefit, personal benefit, under a veil piercing theory.
Well, it doesn't say veil piercing. It says cause the corporation to be used for the purposes of and did perpetrate an actual fraud. But then it adds this notion of direct personal benefit, which is what you think of when individuals who work for companies are directly liable. There's some showing of improper personal benefit, like a bribe or another kind of defamation, anything that might inure to the person's benefit but not to the individual. So I'm trying to work through that.
Right, and I would say that those listings of sham to perpetrate a fraud, actual fraud, and the listing specifically of subsection A2, which we've already discussed in how it draws from the veil piercing language and utilizes veil piercing terms.
Right, but it doesn't have anything about about veil piercing, and two looks at actual fraud.
Is one way they could be read, go ahead.
I'm sorry,
And then
actual fraud, and this was my point, that actual fraud, actual or constructive fraud, that is a reference not to the tort, and in the veil piercing context, actual and constructive fraud is not equivalent to the tort of fraud. And this reference, which gets pulled from the Castleberry jurisprudence, that is a reference to the veil piercing theory and not a reference to the direct liability theory.
So it seems like one way to look at this would be to say the veil piercing protections are very valuable for a holder of shares who is not choosing to act as an officer or an agent of the corporation. But then once you choose to do that under TransCore, we've said you have these other responsibilities and you can be held individually liable for fraud. And it seems like what A2 and B are doing, that one way to read it would be to say, can the holder be held liable in contract, on the contract, for if there's fraud, right? Then B talks about when the holder can be held liable on the contract, but the holder's fraud liability for their own actions as an agent is governed by TransCore. That would be a way to give meaning to B and to this separate liability, it seems to me. Because you've said under A2, what you're holding the holder liable for is the contractual obligation or matters arising from the obligation. And arising from that contractual obligation, which your fraudulent inducement liability doesn't arise from the contractual obligation, because it's not your contractual obligation. You're a third party for that purpose. But it seems to me that B could be given meaning in that circumstance because you have to have a personal benefit in order for you, the holder/agent, to be held liable for the corporation's obligation, but yet you still also have this other separate fraud obligation under TransCore. Is that a way to put them together?
I would agree with that, Your Honor. And I'm out of time, but if...
You can respond.
Yeah, I would wholeheartedly agree with that. I do think that this statute is generally limited, including to just veil piercing liability for contractual obligations of the corporation. I think that's what was articulated by the Third Court of Appeals and should be endorsed by this court.
Any other questions? Thank you, counsel. Mr. Ritchie, you have 5 minutes.
Thank you. Let me first start by saying that Mr. Weller sued on the contract. He's trying to enforce the very contract that he's claiming exists, and then saying that there's fraud, but he didn't sue for rescission. So obviously the negotiating terms that he claims are fraudulent, as I said before, would be true and not fraud if he proves his contract. But I think the most important thing from the discussion that I just heard was it completely ignored the rules of contract interpretation. You know, the general rule of contract statutory interpretation is that there's I think I heard this in a prior case maybe when Mr. Cawthon was arguing on the Medicaid case. But I've argued it myself before to court, and that is when you're looking at a statute and interpreting it, it's like a contract. Things that are in it were intended to be put there, and things that aren't in it were intended to be left out. That's the way we construe statutes in the state. What you will not find in 21-223 is anything that causes a shareholder to now become liable because they're acting in more than one capacity. It doesn't say that. It's not here. It says if you are an equity holder, you don't have personal liability for obligations of the entity or for any matter relating to or arising from the obligation. Negotiating terms there's negotiations in every contract, and some of those things that were negotiated get incorporated into a contract and some do not. Let's assume there's a contract here, and that, to go to Justice Busby's point, yeah, but you still could have a claim that contract doesn't have the terms that that were represented to you were going to be in there. Well, you accepted the contract. And we've got a doctrine of merger in this state. And then when you enter a new agreement, everything that came before that is gone. What's in the contract is presumed to be in it. What's not in the contract is presumed to be not in it.
And it sounds like those might be good arguments to be developed on summary judgment, but your opposing counsel says that there wasn't a motion for summary judgment on file on anything other than this statutory bar question. Do you agree with that or no?
Well, no, I don't. I necessarily agree with it, but I'll go back to the order, which is in the Court's Record, Volume 1275, of what Judge Mousy said.
But you have
in her
to go
order.
back and look at what the order was on, which is the motion for summary judgment. So is there something in the motion that presents another ground other than the statutory bar?
Well, there's evidence that they were acting in their individual capacity to negotiate a contract.
We've been very strict about only looking at the summary judgment motion to decide what the grounds are in front of the court. So if you want to send a supplemental letter, if you find that there's something else in the motion that we should look at to decide what the grounds were that were in front of Judge Mousy, you're welcome to. But
I can't tell you as I stand here that I recall everything that was in that motion. I can tell you that there was no motion to continue it brought by the respondent. It was fully argued, and Judge Mousy said she considered the relevant evidence, the pleadings. She considered the pleadings. Well, the pleadings have this list of what they're claiming as tort claims. And Justice Busby, I don't think we care to submit anything further on it. We are asking you to reverse the Third Court of Appeals and to have this case remanded to trial court for a trial against MDI only on the breach contract claims and on any claims they've made against MDI. But there's a public policy in this state, and it was supposedly enforced even more with the adoption of 21-223, which is if you form a limited liability company and the party that is negotiating knows it's a limited liability company, which Mr. Weller clearly did because his own company, Integritech, is a limited liability company. So he knows he's negotiating, and if you look at I guess it's the second thing we submitted to you, it's from his deposition, and it's found at, real quickly, it's found at, let me just say till I find it, it's in the record. But what he said was, in question to him, during the meetings, did you understand Mrs. Keyes and Mr. Nadeau were there as representatives of MDI? Yes, ma'am. Did you ever have a meeting with Mrs. Keyes where she was not acting as a representative of MDI that you know of? His answer, not that she was not acting as a representative? Sure. And he says, in my eyes, she was always a representative of MDI. Next question, what about Mr. Nadeau? Likewise. We either protect shareholders and officers of a company with respect to acts that they're doing, lawful acts on behalf of the entity, and any acts that relate to or arise out of that obligation that is asserted, or we don't. And if we accept the respondent's position, we will have diluted and negated the very limited liabilities that we intend and we rely on constantly in advising our clients, and which the legislature intended in adopting 21-223. Thank you for your time.
Any other questions? Thank you, Mr. Ritchie. The case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.
Good job, Sam.